All right, guys, again, how you guys doing? This is Erik Corral again, real estate broker, Chicagoland area. And today I have a special guest, one of the preferred attorneys that I work with. I decided to invite him to go over some legal terms and the real estate contract. So again,
Erik, thanks for having me. I definitely appreciate the opportunity. My name is Christopher Lufrano of Lufrano Law. I'm an attorney in Oak Park, but I represent clients throughout the Chicagoland area, Cook County, DuPage. And I'm going to be talking a little bit about the multi-board residential real estate contract. The current version is 7.0, and so a lot of us, refer to it as the 7.0, and kind of just go through it so that buyers or sellers and agents and lenders, et cetera, are comfortable and familiar with some of the basic sections of the contract.
yeah, so again, this video segment, I want to make, I want viewers to, have something to actually go back whenever we explain a real estate contract so you understand exactly what a real estate contract consists of. So, I mean, this is something that we see on an everyday basis. So I know a lot of times when we try to explain it back to clients, it seems like you understand it very clearly at the moment, but sometimes you go back and you read it and you don't quite understand all the terms. So we really want to just kind of summarize the most important terms, or just make it as simple as possible, so that whether you're buying a house, whether you're selling a house, so you have a clear picture of what the real estate contract is. So again, him being the real estate attorney, he sees these contracts on a daily basis. So we're going to cover each page, the main points. I will be asking him questions that I might have as a real estate broker. So even me myself, I have questions on the sales contract. So yeah, let's begin. We're going to be having a full explanation of the multi-board residential real estate contract, the 7.0. So this is the latest version of the real estate templates that we have access to through the Chicago Association of Realtors. So yeah, let's begin. We're going to go with page number 1.
So, Erik, if I can take a step back. So it's important to remember this is a pre-formed contract that the agents have access to. It covers a lot of different scenarios, a lot of different situations. But what our clients need to understand is that it's a contract, and every contract is negotiable. And so even though we've got a preformed contract, depending upon the circumstances or an attorney's preference or whatever the case might be, the attorney has the role in the transaction of being able to make modifications or suggest modifications. And that's an important part that we're going to get to. But let me start off with the beginning.
Okay.
So we start off with listing the buyer's names and the seller's names. Sounds simple, but we need the client's full legal names. Importantly, for the seller side, to make sure that everyone who is on title should be listed as sellers in the contract. That's true of single people and especially for married couples. Both spouses need to be on the contract. After that, we list the address of the property, the permanent index number, and we identify the property. It's not unheard of for there to be a mistake made in this section, and then the parties to the transaction are not sure that they're talking about the same property. And so it's very important that the agent and then the attorney review it to make sure that this information is accurate and is referring to the same property that both sides of the transaction are looking at.
All right. I know one of the things that attorneys, sometimes they don't have access to as much as us, the real estate brokers, is keep in mind that we as real estate brokers, we're the ones that are actually touring the houses during the time of the showings with the buyers. So we are typically the ones that should be assisting the buyers in helping them understand the next section, which is going to be the personal property, what should be included with the sale.
This is a really important section because paragraph 3 of the 7.0 has probably 40 different personal property items that could be transferred from the seller to the buyer at closing. For example, the refrigerator, the oven, stove. Those are all common things and may seem obvious, but there's other personal property items like the ceiling fans or the satellite dish. Whether that personal property is going to stay and be transferred to the buyer or not is something that needs to be very clear. And both parties need to have a clear understanding about what's staying and what's going. And so as the attorney in the transaction, and like you said, Eric, I'll never visit the property, not even once. It's very important for the agent to make sure that they have all the information, and for the clients on both sides to verify that information before they sign the contract, so that when we get to the closing, there's not some confusion or a disagreement about whether or not a particular piece of personal property is supposed to be transferred or not.
All right. So again, paragraph 4, we talk about the purchase price and payment. Again, this is something that already comes pre-filled to Chris, the attorney. So this covers the purchase price, the amount of closing credits that are negotiated through the seller, and the earnest money that would be put up front. So again, as a real estate broker, we make sure that the address is very clear, purchase price is clear, closing costs and earnest money is clear. So I would say...
And Eric, paragraph 4 is probably the paragraph that gets modified the most. If you could imagine, how the real estate transaction plays itself out, the purchase price sometimes gets reduced. The credit at closing may be added to the contract or may be increased. And so the attorneys are in a lot of instances, modifying paragraph 4 to the contract. And paragraph 4 also lays out, some of the expectations of the parties in terms of who's covering what costs and how payment is supposed to be applied at closing. So paragraph 4 is probably one of the most important paragraphs in the contract.
All right. So again, we are moving on to page 2. Paragraph 5, it's going to cover obviously the close date. So typically we tend to put a close date between 4 to 6 weeks. So go ahead and cover a little bit about paragraph 7 with the loan contingencies.
Sure. So paragraph 7 is the financing contingency. It applies only in contracts when the buyer is obtaining a loan. And from an attorney perspective, what we're making sure is that the loan that the buyer is getting is properly represented in this paragraph. One of the most important deadlines that we're paying attention to in the contract is the loan contingency date. And so oftentimes that date needs to be extended in the event that the buyer doesn't obtain the loan within 45 days or 5 days prior to the closing.
So this is definitely a deadline that we see quite a bit. The close date and the mortgage contingency date. So in essence, this basically protects the buyer for being able to basically obtain their financing or having their financing decline without basically jeopardizing their earnest money. Correct?
That's correct. So long as the buyer is making a good faith effort to obtain the loan, is communicating with their loan officer. If they don't qualify for the loan, the seller's not allowed to hold it against them and retain the earnest money.
Yep.
So that's an important provision for the buyer and seller too.
All right. We love to go through every paragraph, but we'd be here for a couple hours. So, all right, page 3, we're going to cover a little bit about property disclosures. I think we covered that in one of the segments in our videos, what it is. So again, property disclosures are, they're forms where sellers have to fill out if they're aware of any latent defects, I believe it is.
Yeah, so the way the law is written is that the seller is required to disclose material defects of which they have actual knowledge. And those are terms of art, and sometimes there's gray areas, but that's the basic rule. And there's one major exception I just want to point out. If the seller has hired a contractor, a licensed contractor who came in, did work, repaired something that was previously defective, then the seller, generally speaking, is not required to disclose that. And so that's important for sellers to know, because I get a lot of questions from clients about whether to disclose something or not, and that's usually the factors we're looking at.
So back to that point, if the seller, out of good faith or just wanted to do some improvements to the house and they hired a licensed contractor, the defect that was improved on does not have to be disclosed. Is that correct?
So if in the opinion of the licensed contractor, which is better than the seller's own layman opinion, is that the defect has been fixed, then the seller is not required to disclose that. That's a specific exception under the residential disclosure laws in the state of Illinois.
Okay. All right. I want to move on to page 3, paragraph 10, attorney review period. I think to me, this is probably one of the most important sections and one of the paragraphs that we stress the most to home buyers. So tell us, what is exactly attorney review period?
Sure. So the attorney review period starts on the date of acceptance of the contract, and it expires within 5 business days, unless extended. And basically, the attorneys on each side of the transaction have an opportunity to propose modifications to the contract. Now, when we started talking about this contract, I said that it covers a lot, but everything is negotiable. And so under paragraph 10 is where attorneys will propose modifications.
Yep.
They can propose modifications, and the other side can approve them or reject them or counter. One of the important things that was added to this version, the 7.0 contract, is that technically under this paragraph, any proposed revision is deemed a counteroffer. And so, a lot of attorneys try in their letters to avoid that harsh outcome, because otherwise you could have a deal fall apart just by the attorney sending a letter. So that's something that the parties should be aware of. But
I think that's a huge point, because right now, with the way the market is, with multiple offers, highest and best, if you lock in a contract and it's accepted, and during your attorney review period you perform a home inspection, which we highly recommend you do. Keep in mind that whatever defects you find on the property and you feel the need that you request, repairs, further credits, like he said, that is deemed as a counter offer, which can potentially be declined? What's the legal word?
Well, basically,
or rejected?
The contract could be construed as being null and void. So that's under the attorney review paragraph, and that also, what you're talking about in terms of the inspections, also applies under paragraph 12 that we're going to get to. But Eric, what's really interesting in this environment, particularly where you, like you said, there are multiple offers. You may have you're representing a seller, and they may say to you, I know we accepted this contract, but can we get out of it because I have someone who's interested in buying the property for a higher price? Under paragraph 10b, that's explicitly not allowed. The seller's not allowed to disprove or provide disapproval of the contract solely based on the purchase price.
Got it.
So that's important under paragraph 10.
I think, if I'm not mistaken, this is going to be on paragraph 12. Is there a certain amount of days that an inspection should be resolved in?
Yeah, so the buyer's required to conduct the inspection within the first 5 business days of the contract, and then if the parties can't reach resolution for whatever issues are raised by the buyer, then if they're not resolved within 10 days, then the seller can either party can terminate the contract at that point in time.
Okay, let's go back.
Sure.
All right. So basically, after after home inspection, you can have up to 10 days, or what? Can you clarify that again?
Sure. So the buyer has to conduct the inspection within 5 business days, and if they have any defects that they want to raise to the seller, either requesting a repair or credit or a price reduction, or to terminate the contract if they're not comfortable with the condition of the home after the inspection, they have to give notice within 5 days. Within 5 and 10 business days, the parties have to reach a resolution. If they can't after the 10th day, then either party may terminate the contract.
Perfect. So summarize that. You could perform your home inspection and modifications within 5 business days.
Yep.
And you are expected to come to a resolution typically within 10 days.
That's right.
10 business days, right?
Correct.
Okay. We prefer not to drag it out that long, but I mean, it is part of the sales contract.
Yeah. Yep. And sometimes circumstances dictate. If you're waiting for a contractor to come to give an estimate, it may go longer. If both parties agree to extend it, then you can extend it.
All right. So moving on, paragraph 13, 14, we talk about homeowners insurance, flood insurance. I mean, if you want to just cover that really quick, briefly.
Yeah, so the buyer, especially if they're going to be getting a loan, a condition of their loan is that they have to buy homeowners insurance, and they're supposed to provide proof of insurance within 10 business days. This, I have to be honest, this provision of the contract is often overlooked by attorneys and not really enforced.
Okay.
That's just what I see. And then flood insurance, doesn't apply to every property. Typically, the lender or even the insurance agent that you're working with would be able to advise whether flood insurance is required for a property.
Yeah. All right. So when we pursue purchase of a condominium or a piece of real estate that has an association that either governs or oversees a subdivision, tell us about paragraph 15.
Sure. So there's a lot of information in paragraph 15, but basically, the seller has to contact the homeowner association or the property management company that manages the property to obtain all of the disclosures, all of the declarations, bylaws, rules, regulations, meeting minutes. Oftentimes, attorneys add additional requirements to this, but basically, the seller, the onus is put on the seller to obtain these documents and to provide full disclosure. The buyer, upon receiving those documents, may find something that's objectionable in there. There might be a prohibition against pets, and the buyer has a dog. There might be a prohibition against leasing, and the buyer is only looking to live in the property temporarily. In addition, the seller is also required to disclose under this paragraph and others as well if there's any special assessments against the property. That's a big drawback, I would say, of owning a condo is that there could be special assessments from the association. And so the buyer needs to be made aware of that by the seller under paragraph 15.
All right. This is definitely something we see in with attached living. We really want to make it clear to the buyers what the rules, regulations are of the building, special assessments, things like that. So, all right, moving on. Deed, title, survey. So I know we covered this, but what is your sole duty when it comes to the title and the deed? Like, what do you guys look for?
Sure. So, the deed needs to be perfect. It is the main instrument, the main document that's used to convey ownership of the property or the real property from the seller to the buyer. And under the terms of the contract, the seller is required to not only provide a deed, but make sure that good and merchantable property, that good and merchantable title is provided to the buyer. There can't be any sort of title exceptions, such as a lien or an open mortgage or unpaid taxes or some type of easement that the buyer would find objectionable. And there's all sorts of mechanisms where the buyer can get out of the contract in the event that these types of issues are disclosed on title.
I got a question with that. What is a common title issue that you face or you've seen in a real estate contract?
Probably the most common is an encroachment. The seller is, generally speaking, required to order a survey as part of the transaction, and then they're required to give it to the buyer one day before the closing. That survey may disclose an encroachment. Basically, one section of someone's property crosses over the boundary line. Typically, it's with fences, and usually we don't make too much of an issue out of that. But there could be more serious issues raised on the survey, which would then would raise as exceptions on title, which could cause huge headaches right before the closing.
All right. I mean, you covered survey a little bit about the potentials about encroachment. So tell us what Broom Clean conditions means on paragraph 20. Broom
Clean is in the eye of the beholder, right? You may represent one client who thinks one thing and another client who thinks another thing. But basically, as we started out saying, in paragraph 3, there are certain items of personal property that the seller is required to transfer under the terms of the contract. only those items should be present in the property. So the seller can't leave behind a couch, a TV, a heavy safe, especially if it's empty. Yeah. Whatever the case might be, there can be nothing in the house, and it needs to be left. So that's kind of on the buyer side, what the buyer expects. And then the seller at the same time is not required to turn over the property in immaculate condition and hire a cleaning crew beforehand. They're just required to empty the property, and basically when they say broom clean, just take a broom and sweep it out.
Now, a lot of times we have the issue during final walkthroughs, buyers expect the house to be immaculate and just 100% clean. I mean, again, broom clean conditions can be interpreted differently by, different clients. So just understand there's always that slight room for error there with that broom clean condition and just in what conditions the house is going to be handed over to you.
And Eric, also, just in general, the property should be in the same condition as when the buyer originally saw it, during the showing and then during the home inspection. So if anything changes, like if there's a leak or there's a roof leak or some other type of repair issue in the house, that's something that needs to be resolved prior to the closing.
All right, so I think you covered a little bit on paragraph 22. Obviously, if there's any special assessments in the property or, anything unconforming, is there anything that stands out that you'd want to point out there?
Yeah, so, there's a lot of different items that the seller is required to disclose. Paragraph 22, though, comes into play a lot of times depending upon the area that we're in and the municipality, might have a pre-transfer inspection. It may require the seller to remedy any building violations before the closing. And so paragraph 22 is where it's made clear that the seller is required to make repairs and to bring the property up to the building code, although sometimes it's negotiable and the buyer will accept it as is. So that's an important provision in paragraph 22.
All right. I think let's move on to page 8. One thing that I want you to cover, and I want you to explain what it is. It's direction to Escrow E. Please emphasize, what is an Escrow E?
So an Escrow E is someone in the transaction who's holding the earnest money. Under paragraph 4, it can be the seller's brokerage, it could be the buyer's brokerage, or sometimes it says as otherwise directed, which could be the attorney on either side in the transaction, although the buyer's attorney, in my opinion, should not hold earnest money, or a title company. So the Escrow E is the individual or the entity that's holding the earnest money. And the key thing to remember is that both sides need to agree in order for the Escrow E to release the earnest money. If there's any sort of dispute, then there's provisions in the contract that dictate how that process is supposed to play itself out. But basically, the Escrow E can't take direction from one side of the transaction versus the other, because the Escrow E, in theory anyway, is supposed to be acting as a fiduciary, at least with respect to the earnest money.
So really quick, I think this is one of the way I explain it at times is, the Escrow E or your earnest money is protected by exactly what paragraph? So number 1, your earnest money is protected by your home inspection. Is that correct?
Yes.
Is earnest money protected by your mortgage contingency?
Yes.
And then lastly, it's also protected by appraisal terms, or if property doesn't reach, if we don't come to an agreement based on an appraisal or a home under appraising?
So one way to look at a real estate transaction overall, and also this contract, is that from the moment it's signed, it can constantly change, and there are contingencies. You could think of it another way as, driving on a highway and there's off-ramps. There's ways for either party, mostly the buyer, to get out of the transaction or be relieved of their duties and requirements under the contract if certain events happen or don't happen. And the examples you raised are the common ones and the typical ones.
Yeah.
If the buyer doesn't get their financing in time, if the property doesn't appraise for what it should, if the inspection reveals things that are objectionable to the buyer, they can get out of the contract and get their full earnest money back.
So in essence, though, if everything were to fall in place, the Escrow E's duty is basically to fund those or deposit those funds essentially to as part of the down payment for the final sale price or sale purchase. Correct?
Right. So the Escrow E is required right before the closing to turn over those funds to the title company, and typically it's represented as a credit to the buyer at closing because it's their money that they've already put towards the transaction and the purchase of the property.
All right, we're gonna move on to page 9. So I think some of these things is something that you can even ask your real estate broker. You know, paragraph 28, time is of the essence. Paragraph 29, confirmation of dual agency. You can always talk to your real estate broker. I really want Chris to cover paragraph 30 all the way into page 10. So just talk about a little bit about contingency to sell. So sale of real estate and what that actually means and how that can affect your potential future offers.
Sure. So this section of the contract are the optional provisions. So they don't apply in every transaction. But a common scenario where they would come into play is when the buyer in the current transaction is has a current property that they're looking to sell. And so the agent will make the parties initial paragraph 30 of the contract, which basically means that the current transaction is contingent upon the buyer's ability to be able to sell their other property, or contingent upon the buyer to be able to get under contract for the sale of their other property.
So just really quick, if I'm understanding this right, so basically, if I'm a homeowner and I'm buying, for example, your house, I can submit an offer with the contingency that my house sells first, and basically from those proceeds, I will be utilizing them to purchase your home. Is that basically
that's exactly
simple what it is?
That's exactly what it is.
So I think this is important because at the end of the day, if the purchaser that's purchasing my house, if their financing doesn't get approved and the deal falls apart, in essence, it allows me to cancel our real estate contract that we have based on that contingency, correct?
That's right.
Okay. Yeah. Perfect. All right. So that covers all the way to page 9. So we're so that was page 9 up to page 10. So we're gonna jump into page 11. I think some of this stuff, like cancellation of prior real estate contract, again, that is just cover that briefly if you like.
So that's commonly referred to as a kickout provision. So if the seller, this is kind of the way that the seller can continue to offer the property with the knowledge of the buyer that they're in the transaction with, if they're already under contract with a different buyer. Basically, they give the first buyer an opportunity to consummate the transaction or to get to a certain point in the transaction, and if they don't, then the seller can kind of kick them out of the deal and substitute them in the buyer number 2. So it's really a powerful provision for the seller, especially in this type of environment that we've been talking about.
All right. From your experience, how many times do you see sales contracts that include either home warranties, well inspections, termite inspections, or even, I guess, after the closing possession, if you want to cover that?
So these paragraphs 32, 33, 34, and 35 are not that common. Although, as an attorney, I wish paragraph 32 was more common. I really do think for buyers,
absolutely.
I really do think that buyers would benefit greatly, and it would help resolve a lot of the uncertainty that the buyer may have in the transaction if they were offered a home warranty from the outset, because it would protect them after the purchase from an appliance or some other type of thing that's covered under the home warranty, it offers them a lot of protection. The well or sanitary system inspections, that is really location.
Yep.
That's location specific. You know, in Cook County, I don't really see it a lot. In some of the west suburbs,
Yeah, from my experience, I see that a little bit more Will County, DuPage County. Yep. So typically homes that are a little bit more rural for sure.
The wood destroying infestation, which is a fancy way of saying termites. Yep. That doesn't come in too often. Possession after closing, you know, that's really case by case. That's used by the seller if they need to stay in the property past the closing date. You know, the best case scenario is that if the seller knows that that's going to be the case from the beginning, that the buyer agrees to it from the outset. More often than not, though, it's just that the seller, for whatever reason, can't get a moving company or needs to stay a week longer or whatever. And so this gives the parties a way for the seller to compensate the buyer for the additional time they're going to stay in the property.
So I want to cover a little bit about this because I have bumped heads quite a bit with other real estate brokers because the perspective, put it this way, the expectation is not set in the beginning. So basically what this is, if you're representing a buyer as a real estate broker, I feel like it's our duty at times to set the expectation that if you're buying a house that is owner occupied, is set the expectation that there might be a possibility that the homeowner might need a couple of days after closing to clear the house of personal property, and they might be willing to pay you what's called a per diem for the additional days they need. The reason I say this is because, you know, as a buyer, if you're expecting a seller to move out a week or two before the actual close date, you know, it's not uncommon that your financing, if it gets declined or whatever happens, your financing doesn't get accepted. You're basically asking for a homeowner to move out, take out all their personal possessions before you can guarantee them of potentially getting a clear close or even guaranteeing them of a close date. So I think this is something that as a buyer's agent, you should set the expectation to your clients that it's not uncommon for a homeowner to need a couple of days after closing so that we're not disputing a per diem or a deposit. So I don't know what your experience has been there.
Yeah, I couldn't agree more. It's a really tricky situation for the seller because they kind of have to have, you know, blind faith that the buyer is going to actually get approved. And depending upon how the timeline of the transaction works, it could be the case that you don't know that the buyer is fully approved or clear to close until 3-4 days before the closing. At the same time, flipping it around, if the parties can extend the closing to allow the seller the time to get out of the property, in my opinion, as an attorney and as the attorney, I'm trying to reduce the risk and eliminate the risk for my client in the transaction. I'd much rather do it that way than have a post-closing possession, because then it opens up another can of worms, which is, is the property in the same condition it was when the seller moved out after the closing? And if it's not, how is that dispute going to get resolved? It's not ideal.
All right, I got a good one for you, Chris. And to wrap up the sales contract, tell us what legally does it mean to buy a property as is based on the contract?
Okay, this is a really, I could spend an hour on this alone. So what it means according to the terms of the contract is that the seller is not making any representations, warranties, guarantees with respect to the condition of the real estate or the personal property under paragraph 3. That's what it means legally. What does it mean practically? To me, in my experience, what it means, the seller is putting the buyer on notice that the seller does not want to make any repairs to the property, and any requests for repairs or credits or a price reduction is going to be met with skepticism. That's what as is means to me.
Okay. So again, just really quick. So, right now with multiple offers being so common and, as is being initialed as a buyer, it's very common. Buyers come in very aggressive. They submit an offer. It's as is. They're willing to take the property the way it is. And then next thing you know, they perform a home inspection and they start finding out a lot of these issues. So if you decide to further request repairs, credits, is that grounds to automatically null and void the sales contract, or is there still a window to kind of negotiate that?
So there's still a window to negotiate that, because even though the as-is condition paragraph 36, strictly states that the seller is not making any representations, it still gives the buyer the right to get out of the contract within 5 days. Yeah. And so because the buyer has that right, it gives with that right comes some power or some leverage, so to speak, in a negotiating sense. So with that leverage, they can use that leverage to try to negotiate credit. I think a lot of times us realtors are a little bit at fault because, we're quick to accept an offer that states as is, where, in reality, it's very difficult to convince a buyer from the beginning without inspecting a house to be, go in there blindly and just say, hey, I'm going to buy this house 100% as is. I think this would be only the case for investors where they're typically doing cash purchases, where there's city violations, and they're fully 100% aware that house can, need upwards of $50,000, $60,000, $100,000 of renovations. So I think as a buyer that's financing, you got to use this paragraph carefully because, most likely you do plan to perform a home inspection on a home you're purchasing. Right, and likewise, it's not really fair for an unsophisticated buyer, not talking about a sophisticated buyer like you were mentioning before, for an unsophisticated buyer to commit to assuming all of these defects without having been afforded the opportunity to bring a professional in there to find a defect. Certainly a buyer is not going to know in every instance if there's a foundation crack or that there's an issue with the roof or there's an electrical problem. They just don't have, in most cases, the sophistication and wherewithal to make those judgments on their own.
Yeah. All right, I agree. So last page. This is, to me, my favorite page of them all. This is where the acceptance date goes, signatures goes, and representation goes. So I don't know if there's anything in detail you want to point out about this page.
So there's a lot of information that can be provided on this page, but the most important is the date of acceptance. The date of acceptance drives almost all of the dates and deadlines in the contract. And so when the seller accepts the contract, they should fill in the date because everyone needs to be on the same page, so to speak, about what the acceptance date is.
Yeah, no, absolutely. There's times, on the listing side, obviously, I'm more on the listing side as years go now, so I start seeing a lot of incomplete sales contracts. You'd be surprised how many times I've received offers with no date of acceptance. So again, this really makes you look like an inexperienced real estate broker if your contract is not complete. So again, just to wrap it up, please, I guess, tell us the importance of fully initialing the sales contracts in the paragraphs that are necessary.
Sure. This is a contract, and there's a lot of flexibility. I've been trying to express that, but at the same time, the legal requirements of a contract one of the legal requirements is what's called mutual assent. Basically, both parties have a meeting of the minds. They agree on the same terms. And so signatures and initials and terms are evidence of the meeting of the minds. And so without them, arguably, you don't have a valid contract.
Awesome point, Chris. Well, guys, that's a wrap. Again, that's a brief explanation of the real estate contract. I think we could spend a couple more hours talking about each paragraph in detail, but Again, this is essentially what you're going to be looking at as a home buyer if you're submitting an offer, and as a home seller if you're going to be selling your property. So again, Erik, I'm the real estate broker from Remax, and then this is again
Chris Lufrano. Thank you, Erik, for having me.
yeah,
Appreciate
absolutely. He's really one of the preferred attorneys that I've been working with. He's very attentive, and he's very knowledgeable. So I think as a first-time home buyer, you'd have a great experience with Chris. So thank you for coming.
For sure.
And yeah, if you guys find this information helpful, please subscribe to my YouTube channel, Erik Properties, and I look forward to working with you guys.